Good morning. Namaste, Pranam. I Ram Singh, legal advisor, SLA, research scholar. Today I have topic the role of ombudsman in strengthening good governance. A critical analysis of its impact on administrative reforms in India. Being an advocate for transparency, accountability, and equality in government is one of the most important roles that the ombudsman plays in ensuring that good governance is maintained. Through the prism of the ombudsman influence, this article takes a look at the Lokpal and Lokayukta institutions, which are two of the administrative reforms, and India has implemented. The purpose of this article is to investigate the efficacy of these organizations in combating corruption, inefficiency in government operations, and abuse of power by conducting an analysis of the pertinent case studies and the legal framework. In addition, the study dives into the role that the Ombudsman plays in promoting public trust by the use of the complaint resolution procedure. When the complaint of the publics are resoluted, means that there is a good governance. Ombudsman plays in promoting public trust, and public trust is maintained and public trust is enhanced. In many cases, these groups are unable to realize their full potential because of the issues and the political interference, inadequate money, and limited jurisdiction. All these are the problems. That's why ombudsman scheme is not fully active in our country. The full potential because of the issues and the political interference, inadequate money, limited jurisdictions. And based on the finding of this research, it is argued that the Indian ombudsman system requires adjustment in order to enhance its autonomy, scope, and effectiveness. We advocate increasing public awareness, ensuring that investigations are conducted impartially and using technology in order to make grievances resolute redressal procedures very accessible and responsive to. Through its role as a check and the balance, the authority of the government through its role as a check and balance on the authority of the government, the ombudsman in administrative law is a representation of the fundamental principles of the democracy. Fundamental principles of the democracy. The representation of the fundamental principles of the democracy may be possible only in case of the by giving the resolution and grievance redressal to the citizens of the country and safeguard the rights of the public and rights of the citizens of this country, and the government entities are held accountable for the action they take. If they are taking biased actions, they are biased decisions, that should be checked, and check and balance should be established. The ombudsman position in administrative law that functions as a guardian of the individual rights. Guardian of the individual rights. Why all these agitations were done? Because the ombudsman is the guardian of the individual's rights. Will protect the right of the public of this country and the citizen of this country. The devotion they demonstrate every day because they are devoted to safeguard the right and protect the consumers and citizens in a way, governance way to citizens. Meaning of the ombudsman in administrative law in the field of administrative law and ombudsman is a self-governing official or body that has been designated by the government to oversee and investigate complaints and grievances concerning administrative act and decisions taken by the governmental agencies and department or public bodies, executives, whatever the decision they take and they are viable, and they are supposed to be investigated, and grievances if raised by the public and citizens come to the ombudsman, they are supposed to investigate the matters and give unbiased results without prejudice. They have to treat both citizens, grievances, and the officials. In the field of administrative law, the primary responsibility of the ombudsman is to ensure that the governmental administrative procedures adhere to legal procedural standards, as well as ensure that they are transparent, equitable, and accountable. The term grief officer is typically used to refer the particular individual. The primary responsibility of the ombudsman is to evaluate complaints lodged by the citizen on what they believe to be deficiencies in performance of the government agencies. Locals have the ability to voice their issues to this individual and who works within the government, but maintain their independence and impartiality. In essence, if the government is not functioning effectively, locals can communicate their problem in this official ombudsman complaint to the ombudsman. Means that the primary responsibility of ombudsman is to evaluate the complaints filed by the citizens of this country against the government agencies and government officials. And government officials are supposed to work uh, supposed to work without prejudice and without bias. If they are working using their own positions and abusing their positions, are another way of uh, white collar crimes. We can say white collar crime. Then they are supposed to be there. They are supposed to be investigated by the ombudsman when any citizen or resident complained there. Importance of the ombudsman in administrative law with regard to the significance with regard to the significance of uh, this particular this particular ombudsman, and in administrative law it is the utmost importance to acknowledge that this individual is not a super administrator to whom one can appeal solely because of the discontent with a decision that was made by the government officials. One of the key responsibility of the ombudsman is to investigate complaints that are associated with incorrect management and unfair treatment. If unfair treatment and incorrect management has been carried out by any governmental agency or government official or officer, then ombudsman, it is duty and responsibility of it is up to the ombudsman to investigate the matter and take appropriate decision and give their own decisions on the subject matter, that so that the citizen and the citizen and the public could be satisfied. In the framework of its application, the ombudsman and the administrative law can be brought and thought as a guardian of the operation of the government and supporter of the common people. Every citizen who lodges a complaint against that they consider to be misbehavior, inefficiency, unfairness, misbehavior, inefficiency, and in, misbehavior, inefficiency, dishonesty may be also there, and common people, every citizen who lodges a complaint considers that the government is subject to an investigation by the ombudsman. Means that they are a agent, they are the authority, they are as a authority. Ombudsman is an authority in administrative law that is thought as a guardian of the operation of the government and support the common people of this country. And common people can go directly to them and lodge a complaint, and on base of their misbehavior, inefficiency, unfairness, and any dishonesty, They are supposed to be investigated, and the results outcome on base of the outcome given by the ombudsman, they are supposed to be punished. A significant amount of the jurisdiction is vested on the ombudsman, which includes access to records led by the government. Those who file complaint are not needed to provide evidence. There are in court procedure, when you are going to file a court case into the court of law, you have to produce the evidences also. But in this ombudsman cases, you are supposed to complain to the ombudsman, and it is ombudsman who will collect all evidences against that particular authority and agency and officer. Now, what is the objective behind this? Objective. I have taken only two objectives. That's why the research may be possible, and maybe outcome may come. To review the Ombudsman, Lokpal and Lokayukta's ability to resolve complaint and provide administrative transparency. Administrative transparency, मतलब resolve complaints and administrative transparency. There should be transparency in working of the any governmental agency or officer or any authority, so that the public will feel that, the citizen will feel that the governance is going on in a good way. To examine the challenges and the limitations faced by the ombudsman system in India. One, the ombudsman, it is authority. What is the authority of the ombudsman? And second, the ability and authority. And the second is the what are the restrictions and what are the challenges before the ombudsman system in India. Yeah, 2 points are there to be answered. Method. This study employs a qualitative method by a literature analysis to elucidate the efficacy of the Indian Ombudsman. Miliong 2008 assert that the qualitative research methods are a research procedure. Qualitative research methods are a research procedure that yields descriptive data in form of written or spoken language from individuals and observed behavior. Qualitative research necessitates direction in the development of the substantive theories derived from the evidence. Qualitative research. Qualitative research means we have to collect the data from the written and spoken individuals, written or spoken way from individuals and observed behavior. So whatever the citizens, whatever the members of the society have observed. Result discussion, how the result will come out. Assessing the effectiveness of the ombudsman's addressing grievances. The ombudsman system in India, consisting of Lokpal at the national level and the Lokayukta at the state level, was established to combat corruption and resolve grievances associated with maladministration in public offices. The efficacy of the organizations can be assessed by the multiple metrics such as case resolution rates and the accountability enforcement, transparency enhancements, and overall governmental impact. What the governmental impact are there, and how you can come out the result can come out of governmental impact. What are the overall governmental impact, or what are the overall governmental impact there. Case resolution and the grievance redressal. Assessing the effectiveness of the ombudsman in addressing grievances, we have to assess that whatever decisions and whatever investigations and whatever the procedures been taken by been applied and implemented by the implemented and taken and support taken by the ombudsman are effective in addressing the grievances, and how many cases been resoluted and how the cases were resoluted. And second is the case resolution and the grievance redressal. And national level, at the national level there is Lokpal, and in first case also there are the national level Lokpal and state level Lokayukta. Recent reports indicate that the Lokpal has addressed a limited number of instances relating to the expectation established at the time and law enacted. Somewhere, state level, Lokayukt are doing well, and and Lokpal members and the logical challenges in the establishing the agency has impeded the capacity to process case effectively, notwithstanding significant and public need for vigorous anti-corruption oversight body. The case resolution rate remains low. Some in some states, Lokayukt are working in a good and appropriate way, and several cases being sorted out. And but in national level, the decision making process and the action of the Lokpal are very low due to constraint like politics, government, and other regions may be there. And we will come out with the result that what are the main reasons. State level, the efficacy of the loci differs markedly among states, and some states are doing well, some states are not doing well. Some states ombudsmen are very silent and they are not acting at all. Promotion of the transparency in administrative process, the fear of accountability. Fear of accountability, it should be the fear among the officers and agencies of the government that their working is under, कहते हैं there is a surveillance, under surveillance, urban under surveillance. And ombudsman may be treated as a surveillance that there is a ombudsman and the government agencies and officials have to work in an appropriate way, and they are not supposed to misbehave. They are not supposed to do dishonesty, and they are not supposed to do unfair practices. Public access to information, what the information are there, the public can have through RTI and through another way, and they have the right to know what the ombudsman and what the governmental actions are going on, what the ombudsman had done, and what the governmental actions are going on, what the governmental agencies are doing, are in a appropriate way, or in an unfair or misbehavior way. Public perception and trust, public awareness. If public is more aware about the ombudsman, it means that they will have information through RTI, and they will have information through other sources. And if there is unfair practices, misbehavior, dishonesty, and any corruption there is involved, that they can directly report to the ombudsman, and ombudsman will investigate the case and will resolve the case, and that's why that that way public trust will be established. Impact are Impact on public accountability. Over time, the Lokpal and the Lokayukt have achieved gradual advancement in enhancing accountability, especially in states where they operate free from the political interference. It is sure and certain that when any law or any appropriate authority is passed through the parliament, by the parliament, and by the parliament and established in a statutory way, people, officers, and other those who are involved and those who are under that scanner will have some fear, and that fear should be maintained so that they could not do dishonesty, unfair practices, misbehave with the citizens of this country, and corrupt practices should be diminished and reduced. Challenges and limitations faced by the ombudsman system in India, and there are several challenges. That's why ombudsman is not active, and Lokayukt are also. Some chief ministers are very strong, and they are doing free of mind. They are doing their work free of mind, and they are posing that they are the constitution and they are the supreme authority. That's why Lokayukt are not active there. Active there. Exclusion of key functionaries. A significant shortcoming of the ombudsman system in its confined jurisdiction. The Lokpal's jurisdiction includes lower level government officials who often interact with the public and are more susceptible to corruption. A significant number of these officials operate within local government entities and agencies that engage directly with the citizens. Hence, constraining the Lokpal's capacity to tackle grassroots level corruption. Whatever the grassroots level corruption Lokpal, Lekpal, Patwari, and so on, and other clerk, Babu, and section officers are doing, they are not under this Lokpal. That's why the grassroots level exclusion, investigation exclusion is paying some drawback. Limited coverage of the Lokayukta, though limited coverage, certain states have broadened the Lokayukta authority and encompasses all officials and government entities, hence diminishing their capacity to address a comprehensive analysis. And likewise, the Lokayukta in the numerous state possesses constant jurisdiction. Constant jurisdiction. So that's why if the chief minister is powerful and governor is powerful, the Lokpal may be advisory role only. The Lokpal and Lokayukt are giving advisory role. That's why they have no such power like judges. That's why this is one of the drawback. Reliance on the agencies. They are dependent on the agencies like CBI, ED, and whatever there are the agencies doing investigations. They are dependent on that. So this dependency will also join a drawback, because if CBI will investigate and CBI is not going to give a good investigation results on a particular case due to the compulsion and due to the government pressure, then ombudsman can do nothing. Politicize appointment. Politicize some cases may be in some cases ombudsman, Lokayukta and Lokpal may be appointed with a political notion that you are supposed to do like this, and you are supposed to you are not supposed to uh, defame the government by investigating the matters and giving your result against the government. Political influence on functioning. Political influence is functioning. There are pressures, peer pressures, and inadequate funding and staffing, and there are problem in funds and staffs, and there are not a adequate number of staffs. That are also a reason. Lengthy investigation process. The investigation process took time. That's why the result are not possible in 1 month or 2 months or 3 months. Lack of public awareness. People are also not aware. Complicated complaint procedure. Yeah, this procedure is very complicated. Some may be able to report there and some may not be able. The efficacy of the Lokayukta differs significantly, and the procedure for the submitting complaint to Lokpal and the Lokayukta is frequently bureaucratic and integrate. It necessitates extensive documentation and adheres a protracted procedural pathway, and that deters many from seeking the ombudsman assistance. बहुत लोग ऐसे होंगे जो लोगों को डर लगता है, उन्हें they will not go there, and they will be they will left the way in a midway. And moreover, digital access of the grievances in the content, that thus diminishing accessibility of the individual in the remote regions and lacking technological resources. If Jharkhand and Chhattisgarh and other remote areas, where MP, UP remote areas, Rajasthan remote areas, they are not able to access the internet and other online services. That's why they cannot report online, and they are also not able to come to the ombudsman. Uh, Variability among Lokayukta, and there are several variations in Lokayukta. Some differs. Some state Lokayukta are working like so, and some Lokayukta of the state are working like though. Thus, resulting in an uneven influence on governance and accountability. It is in states like Karnataka, the Lokayukta has been vigilant to combating corruption, but in UP it is not effective. Failure to address the system corruption. And the ombudsman system in India has predominantly been reactive, focusing on individual grievances and instead of proactive combating system corruption. Although Lokayukt have achieved success in several prominent cases, There are examples, and Lokayukt have done well, and they are doing the well. And in some states, in Karnataka, as an example, is a very efficient, has a very efficient Lokayukt, and Lokayukt are ineffective due to some this region. Although Lokayukt have achieved success in several prominent cases, the overarching issue of the diminishing corruption in the routine government persisted, and particularly in places where the Lokayukt are ineffective, there are more activities of misbehavior, dishonesty, and corruption. In light of the fact that the majority and the ombudsman is comprised of the recommendations, there is a reasonable concern regarding the ombudsman inability because of the I have explained 12 regions. I have explained 12 regions. All these 12 regions slow the speed of the ombudsman and Lokayukt, and make available to the public the frequency. The document that may be ombudsman make available to the public is frequently considered to be an insufficient instrument for influencing administrative procedures and practices. Informing the mass media and educating the general public as an additional point of interest, it is duty and responsibility of the elected governments to convince and to advertise on all these matters that there is Lokayukt, if there is corruption in the particular department, you can report to do like this, like that. It is duty and responsibility of each of state, and it is and divisional in charge or a district in charge of any district. The ombudsman ought to concentrate not only on the laws and regulations that are correctly in place, but also on the possible next interpretations. And but they are not able to interpret on that. They are not able to interpret on that. That's why there are some problems. On that problem might be sorted out. Otherwise, there will be no reform, and there will be no control. There will be no good governance. In the light of the fact that the majority of the ombudsman authority is comprised to recommendations, there is a reasonable concern regarding the ombudsman inability to enforce the annual report, which is often the only public document that many ombudsmen make available to the public. Ombudsman offices give whatever the papers they give on papers, newspapers, and in order to make aware the citizen of this country and the nation, people of this nation, the annual report that are annual reports, and which is often the only public document that may ombudsman make available to public, is frequently considered to be an insufficient document for the influencing administrative procedure. They are not giving good influence. The procedure, and as a national point of interest, the ombudsman normally does not have the authority to change or reverse finding. They cannot change and they cannot reverse find. Whatever they have the finding, they are not able to change that particular department and do that governance. Rather than the focusing simply on the administrative procedures, and there are others who argue that the authority of the ombudsman should be expanded so that it can be used to bring about the changes in legislation and the policy wherever there is the matter of law and there is matter of fact. This ombudsman should have such authority, and they can suggest and they can propagate the way. That's so that the proper guidelines and reforms guidelines uh, should be structured to control all these anomalies. The Ombudsman ought to concentrate not only on the laws and regulations that are currently in the place, but also on the possible next interpretation of the laws and rules. So whenever they feel that these laws are not appropriate and perfect under the circumstances and the fact of the case, they should suggest that there should be law so and so. There should be law so and so. They should demonstrate, and they should also give suggestion to the legislators. But they are not empowered for that. Should be expanded. their power should be expanded. It is the base result. They are actually not working properly and in appropriate way. Lokayukta and Lokpals, our ombudsman is not working, ombudsman institution is not such effective as it was desired. And also there are some compulsions from the government sides, and the elected governments are using their own power, and they used to suppress or pressurize the ombudsman and Lokayuk. And the third is that they have no money and powers. They have no suggestion power. They have no also any judicial powers. That's why the ombudsman ought to consult it. No, ombudsman has been given uh, powers, but that powers are not enough to eradicate the corruption, to eradicate the misgovernance and misbehavior by the governmental agencies and government officers. Thank you. And they should have also they should have given power to investigate the lower level officials also, because public are very much connected with the Lekpal, Patwari, Pradhan, Master, teacher, head, basic Shiksha Adhikari. All these are not under the HJ scanner. That's why corruption cannot be eradicated unless until grassroots level officers are not investigated by this particular institution. Thank you very much. Like, subscribe, and share.